Let us bow our heads at this time. Father, we give you thanks and praise and glory. We thank you as we reflect on your word from Philippians chapter 4. Whatsoever things are good, whatsoever things are lovely, whatsoever things are of good report, if there be any virtue or any praise, let us think on those things. We thank you today, therefore, for your goodness towards us as your people. Thank you for keeping us and watching over us, and even as the members of this honorable house are gathered here today to discuss the matter that is on the agenda. We pray, Heavenly Father, that you would remember them in a special way. We pray for guidance, for strength, for wisdom, for understanding. We pray, Heavenly Father, that you will continue to lead even those that are in authority, that they would do the things that are pleasing and right before you, and they will constantly, Father, call upon you for your direction. We pray for the Speaker of the House as he presides over the House today. We pray that you will grant him wisdom and understanding as we commit all things in your hands. In the name of the Father, the Son, and of the blessed Holy Spirit. Amen.
Amen. You may be seated.
Confirmation of minutes. Minutes of proceedings of the 16th meeting of the 4th session of the 12th Anguilla House of Assembly.
If there are no amendments, can someone please move that the minutes be accepted as circulated?
Mr. Speaker, I move that the minutes are accepted as circulated.
Mr. Speaker, I rise to second.
All those against? The ayes have it. The minutes of the 16th meeting of the 4th session has been confirmed as circulated.
Oath of allegiance to new members, none. Announcements by the direction of the Speaker.
Good morning. I give apologies for the Honorable Madam Speaker, who's absent with reason, and the Honorable Deputy Governor, who's also absent with reason.
Questions? None. Government statements on recent developments? None. Papers? None. Reports from committees? None. Petitions? None. Government notices? None. Private members' notices? None. Motions? None. Personal explanations? None. Other business, government business? A bill for administration of justice, Special Provisions Act 2024, second reading.
The Honorable Attorney General is recognized.
Good morning, Mr. Deputy Speaker and members of the House. Mr. Deputy Speaker, I beg to move that a bill shortly entitled the Administration of Justice Special Provisions Bill 2024 be read a second time.
Mr. Speaker, I rise to second.
Many thanks once again, Mr. Deputy Speaker. So, Deputy Speaker, what is before us today is quite a comprehensive bill. What I propose to do is to summarize aspects of it in relation to the explanatory notes which are appended at the back of the draft legislative instrument. But by way of introduction, allow me to say that this piece of legislation has been long in coming. It emerges from a recognition that in the judicial system, certainly the domestic judicial system, there are always a need, or there's always the need to improve the administration of justice. But particularly so in our experience operating the system here, where vulnerable witnesses and children are concerned, particularly in the context of sexual abuse and sexual offenses. Over a considerable period, some 3.5 years, the drafting team, together with officers who engage day-to-day the social services division of government operation, as well as other stakeholders, worked out this draft piece of legislation, which I'm given to understand may be a model for others in the region. There is keen interest in what we do here today. I can say that some of my colleagues, particularly in St. Kitts Nevis, are looking forward to see the final product of this legislation. The bill intends to improve the processes of the administration of justice and the procedures for balanced criminal justice and the protection of vulnerable witnesses, so as to enable an environment or a more comfortable environment for those of tender years and those who are, by reason of special circumstances, vulnerable or intimidated, and whose evidence may be compromised by fear, threat to life, and the like. The measures in this bill go a little bit further in their reformative reach. The bill introduces for the first time the prospect of a judge alone, or what you call a bench trial in criminal proceedings. The modality introduced here in this bill is not very dissimilar to what is now the case in Antigua and Barbuda, but not quite the same. In relation to judge-alone trials in criminal proceedings here, the procedure is that parties may apply for this to be so. Both the prosecution and defense either may apply for the conduct of the trial to be done by a judge without a jury, or the court, having view and analysis of objective conditions and circumstances, may direct the trial to proceed without a jury. Of course, with reasons, written reasons being given. So that there is no imposition of it. It is a means or a mechanism available to parties and the court for a more efficient trial process. What is the importance of that? This was not introduced because it is fashionable. And by fashionable, I mean, Mr. Deputy Speaker, It was not introduced because there is a tide or necessarily a movement in that direction by other territories and states. That may be so. Indeed, the outgoing Chief Justice was very interested in the first iteration of this piece of legislation because, for efficiency's sake, the modality of a judge-alone trial lends itself to a more efficient and speedily proceeding in the court. But consideration was given to this mechanism because it is sensitive to certain conditions, which in the case of Anguilla, like many others, those conditions, though they may not arise with regularity, but they do from time to time arise. For example, it is a better modality for conducting a trial where there is a criminal proceeding that attracts considerable publicity. Publicity which over time, and with the instrumentalities we have available now to us with social media and various kinds of recording and commentary, might generate very negative and prejudicial pretrial publicity, which might make it very difficult, if not impossible, for a fair trial before a jury in a small jurisdiction with a small jury pool to be possible. So with a judge-alone trial, we ameliorate the eventuation of such a risk in that context. One can also think of other kinds of circumstances which are very familiar to us, where there is a spate of violence, perhaps territorial by gangs, and the safety, if not the lives of witnesses, are at stake in relation to the effective prosecution of those offenses involved in that kind of criminal activity. The mechanisms involved here with judge-alone trials and protection of witnesses who may be, in this context, intimidated, and witnesses who, in this context, may require anonymity orders and other forms of protection. This piece of legislation is more than a timely reform. In relation to what I mentioned earlier, the explanatory notes which are before this Honorable House and colleagues, I don't propose to have intercourse with all of them as they are written and in plain black and white. But allow me to touch on a few of these before I make some other short comments and take my seat. Emergent from the consultative process that this piece of legislation underwent, and having considered the commentary, formal commentary of the Bar Association here in Anguilla, members of the public who emailed in commentary, and those who attended our session, amongst others who are not necessary here to mention. Adjustments have been made to the draft bill. Some of them, or all of them, have been reduced into the proposed amendments for the committee stage, which will come shortly. And we are grateful for the input of all who have seen it fit to give constructive and meaningful commentary and recommendations on this reform measure. In relation to this bill, Mr. Deputy Speaker, important to note, as I mentioned before, but let me touch on those areas I consider are best served by our deliberations here today. The bill features special measures, directions in case of vulnerable and intimidated witnesses. These procedures and these powers and mechanisms, of course, are contained in Part 2 of the bill. They apply to criminal proceedings. That part, that is Part 2, makes provision for granting of special measures, directions in case of vulnerable, intimidated witnesses. A witness may be eligible on this part for special measures direction to be given to him or her where the witness falls within one of the categories defined in Clause 2. And those categories are measured as against objective conditions, which, when they coalesce together, they provide the entitlement to the protection. And so the court would grant those measures. Those measures, as I indicate, are particularly important because in our experience, certainly at the chambers, where the conduct of criminal proceedings are largely entrusted to the Attorney General's chambers by virtue of Section 34 of the Constitution. Certainly in my experience, there have been several abortive and aborted trials involving young persons in conditions of alleged sexual abuse. More often than not, young women. And there are a host of reasons why these trials, the majority of them, do not proceed to finality of a verdict. But chief amongst them, in my experience, are certain familial and community pressures where the abuse occurs in a family construct where there is a dependency on the male figure who, more often than not, is the offender. And other relatives put pressure, and when I say pressure, I don't mean physical coercion. I think it's readily comprehensible what I would mean in this context. And the victim quite often declines to continue to give evidence. And we do not have here in Anguilla provisions for victimless crimes and laws where victims are isolated and coerced, if, well, for want of a better expression, to give evidence even though they have withdrawn their consent to proceed. Neither would I recommend it given our constitutional construct. And so it's quite difficult to obtain balanced justice and effective justice in that context. So these measures, which can be fashioned by the court to best suit the situation of vulnerability, are vital in tackling that scourge. And so, Mr. Deputy Speaker, honorable members, I'm quite happy that we've been able to come up with provisions that would enable the court in an evenly balanced way to do justice in such circumstances. Apart from special measures, an important and very serious reform introduced by this bill is both procedural and substantive in its nature and effect. That is to say, at our clause 29, dealing with the pursuit or questioning a witness on that witness's sexual history or activity. Now, already at common law, lawyers will know that there is a general prohibition from pursuit of that line of questioning. However, it is open where what is sought to be extracted, elicited, gathered, is relevant to a defense which the accused mounts. But there has never been a structured legislative intervention that had worked in this particular situation. There were attempts in the United Kingdom. We looked at those as well. And that had been bedeviled by lawsuits, ineffective drafting, multiple drafts, and to almost complete abandonment of any legislative intervention in that regard. Happily, strides have been made elsewhere, and more recently, other parts of the Caribbean which are consistent with our constitutional mandates and our jurisprudence, to come up with a procedure that is fair and balanced to both the victim and the accused. Quite often, before I say something further on that, I think something must be said about the approach to criminal justice reform, particularly with measures such as this one. Quite often it is believed that in our judicial system and our constitutional system that, and it is a common misconception, that though there is the presumption of innocence when accused of any crime, all the procedures of the court and procedures on the law must in some way give a partial generosity to accused persons because nothing is established against them by way of guilt. That's a misconception. The scales of justice are evenly balanced, and the rights of persons extend only to the territorial limits of the rights of others, which indicates that things must be balanced. What is attempted here is to ensure that victims are protected, not in a manner that proceeds from some assumption of guilt of the accused, but in a way that is sensitive to the objective realities of victims, their conditions, the environment of the court, and their sensibilities. For instance, Mr. Deputy Speaker and colleagues, quite often there are cases where you have sexual abuse of, let's say, a young woman under the age of 11. And as it stands today, much of our criminal proceedings, or procedure that is, or the procedure, exposes that victim to the ordeal of recounting the experience, the traumatizing experience, twice, if not 3 times. To what end is that? Are we not interested in getting at the truth? Are we not interested in assisting our young people to speak up so that we can better deal with sexual abuse? Indeed, no crime is one that you can completely eliminate, but our systems exist so that we can deal with them, suppress them, and protect those who have the trauma of encountering that kind of behavior at an early stage in their lives. So I return to pursuit of sexual background and sexual history. Quite often that exacerbates trauma and it creates an unfair situation, especially where that history is not relevant. And so the mechanisms are put in here for the court to test the relevance of the pursuit of that line of questioning. It is restricted, but it is not prohibited. It is restricted, but it is not prohibited. And courts exist, and we must trust the courts to do justice in any particular situation. What we seek to do is to give the courts the tools to do so, not to tell the court what must be the answer in every situation. That is for those who turn the wheels of justice. And so I'm quite happy in relation to procedural mechanisms for dealing with that very real situation which often occurs in a criminal trial, particularly where sexual offenses are being tried, that there is a mechanism for screening the pursuit of a victim's sexual history to avoid not only embarrassment, but to avoid creating the unfair perception, particularly where there is a jury, that because of a certain kind of sexual history, the victim is not to be believed. That is quite important, very important. And so the judge alone trial mechanism, as I indicated earlier by way of introduction, is not an imposition. It's a facility available, and there are the procedures built into this measure to obtain such a trial and that govern how it is to be conducted, including as to how the court is to deal with evidence and render a verdict, which must at all times be written and reasoned, because there are rights of appeal, which we have provided for, both the prosecution and the accused. Members would recall that for the first time we legislated prosecution rights of appeal in 2021 in an amendment to the Supreme Court Act. This measure seeks to repeal that, in part because of the introduction of judge-alone trials and the mechanisms that are inherent in the conduct of proceedings under that model, and so there must be provision for an appellate pathway. Allow me also to mention of importance here is that in consequence of our engagement with colleagues by way of consultation, and upon reflection, there were initially, and I'm sure my colleagues who are familiar with legal proceedings, first, or certainly the iteration of this bill, that came before the House at the time of the first reading, there were quite comprehensive appeal mechanisms in favor of prosecution rights of appeal. Those involved appeals where a terminatory ruling might be made or might have been made, and where an evidentiary ruling might have been made. Mr. Deputy Speaker, members, we have considered that those provisions, those proposed provisions, be entirely removed. They were drawn from the Criminal Justice Act, I think, 2003 in the United Kingdom. After speaking with colleagues, I consider that they are to be removed principally for two reasons. Number one, the animating purpose of this bill is to achieve efficiency. In addition to protecting the vulnerable, etc., but it's to achieve efficiency in the criminal justice system in our small context. Those mechanisms that I just mentioned, I consider to be removed, and they are before us here today. Will protract a criminal trial. That certainly is not in the best interest of accused persons, and clearly not in the interest of witnesses, particularly those who are victims involved in the proceedings. The second is this, that I have said before, that though useful it is to look to see what other territories are doing or the countries are doing, legislation promulgated here must be context sensitive. And in the United Kingdom and other places that have these elaborate procedures, which we consider to be removed, the criminal trial process and the administration of justice as a whole are supported by very complex and well-funded welfare systems and legislation. We don't have that here. So there is no point in borrowing it and inserting it here if it will not work well. It is ill-suited. So we have sought to remove all of that. Importantly, we have recognized the march of technology and its use in the conduct of proceedings, and certainly in the overall administration of justice, for giving evidence, both the accused person and for witnesses, whether vulnerable or not. An important stride also is that in an effort to aid vulnerable persons, or certainly vulnerable witnesses, I should say witnesses, to better give evidence so that certain kinds of crime are not just the subject of rumor and swept under the carpet, but they're appropriately dealt with. There is now the mechanism where the evidence of a child of tender years can be recorded. Of course, the mechanisms are here for intermediaries, social service support. And again, it chimes into what I mentioned earlier about creating the environment that lessens trauma so that the vulnerable, those of tender years, those victims, can better give the evidence so that we can get at the truth and we can deal with the abuse of our young people. This is an important stride, which in my view does not require any fancy technological sophistry to do it. Police are already internally recording question and answer interviews. Just by mechanisms here, in a different context, the recording is done for a particular purpose and will be sanitized according to what this says. It may require, I correct myself, it requires a fair measure of training, but to be quite honest, Mr. Deputy Speaker, colleagues, I think it is much more than training. Sensitivity. Because in my experience here in office, where sexual abuse occurs, or even sexual violence, in a domestic context, I will choose my words carefully. It is not that the police are not interested in proceeding with them, but there is a cultural motif, sort of, where there may be a cynical approach to complaints of domestic violence, sexual abuse in that context, where people may say, I don't want to get involved in woman and man business. Right now, I don't know if colleagues have been following, there is a major, although it's a court case, it's also a social movement in Trinidad and Tobago because of the death of a young lady, I think 5 years ago, where reports have been made, not just of physical abuse, but psychological and sexual abuse. And the response from the law enforcement and the prosecution authorities, it is said, because it's still being litigated further up the line, was less than satisfactory. And it has now ballooned into a question of the obligation of states and territorial governments toward citizens, towards the people, to afford effective protection of their human rights and dignity by first a cultural and social sensitivity to this phenomena of violence and sexual abuse. So I think, Mr. Deputy Speaker, colleagues, it begins not really with a formal training, because people have gone through several seminars and webinars and so on. While that is of some utility, and it is good, a very deep appreciation of your community and an immersion with compassion and understanding of these situations is what will inform your response, your scrutiny, and your investigation of complaints in this regard. In short, we ought not to be cynical and brush it off and just say that is in a domestic context, you don't want to get involved in these things. It is important that we not just enforce the law, but we protect our citizens, protect our neighbors, protect our young people. Indeed, you cannot legislate everything, and so a bill will not have everything. But we must start somewhere. And we have more than beginnings here. As the Deputy Speaker and members would notice also that there are other general and miscellaneous provisions in this bill, but chief amongst its interventions, by way of summary in closing, are the special measures for the vulnerable and the intimidated, Number two, the protection of witnesses in the pursuit of their from the pursuit or unreasonable pursuit of their sexual history, which may malign them and marginalize them in the course of seeking justice. That must be judicially controlled, and this is what we seek to do. Judge-alone trials, which would be a useful mechanism because it is sensitive to certain situations that a lay jury would not be able to effectively manage for qualitative justice. And I've given an example or two examples of practical situations and scenarios that may arise where this modality of criminal trial will be vital. We have made intervention where unrepresented accused persons are not disadvantaged, particularly in sexual offense cases. I harp on those things, sexual offense cases, because they are a unique challenge in our criminal and in our court systems. And by way of illustration how evenly balanced we have attempted to make the reform interventions, where you have someone who's accused of sexual abuse. Perhaps they're indigent, can't afford a lawyer, and we don't have complex legal aid as they do have in Canada and the United Kingdom. But there is a mechanism here for the critical elements of the trial where there is an examination of the complainant who has brought you to court on this allegation, that the court will direct and the court would enlist counsel, not randomly, provisions are made on how that selection is to be made, to act for the accused person in relation to that portion of the trial. Because as you know, though accused, you have a right to silence, except when the trial gets to a stage where there's a case to answer, you have to put forward a case. And so these elements, these corners and contours, we have tried our best, given best practices internationally and with reforms elsewhere, particularly also sensitive to our conditions here. We have made some interventions here by the measures we propose. I touched on anonymity orders. Those orders serve both the defense as well as the prosecution in the protection of witnesses and to protect the integrity of a criminal trial before the court. In March, with the advancement of technology, we have recognized and codified both, civil practice directions relative to the conduct and use of live link evidence and adducing evidence that is by live link, uplifted its use in relation to magistrates' court to be a corner piece of this legislation so that it is applicable in both courts as a matter of course where conditions are satisfied that justice requires that the use of live link for taking evidence would be necessary and convenient. We've also provided that as a means also, further means of ameliorating double trauma to witnesses that are vulnerable, that the preliminary inquiry into offenses against them, that is the offenses of violence and sexual abuse, are going to be by people committals. And so at that stage, there will be no cross-examination of the young victim. That will come at trial. These, Mr. Deputy Speaker, members, are essentially what this bill seeks to achieve. It is largely procedural in that it alters the way and the manner of approach to many of these proceedings. Those parts that some thought were going to interfere with substantive law, many of them had been made controversial by that concern, have been removed. And we are satisfied that the removal does not dilute the essential object of this bill. I will have the opportunity, Mr. Deputy Speaker and members, to address certain aspects, either by way of elucidation shortly and thereafter. But I commend this measure to the whole House for consideration today and passage. I'm grateful, Mr. Deputy Speaker. Thank you.
Thank you, Honorable Attorney General. I now invite debate on the merits and principles of the bill. Honorable Member for Sandy Hill is recognized.
Thank you. Good morning, Mr. Deputy Speaker. Good morning to members of this Honorable House and to members of the public. Mr. Deputy Speaker, I rise in support of this Administration of Justice Special Provisions Act 2024. And I would like to first commend the Honorable Attorney General for his thorough and exhaustive explanation as to the contents of this act, not only for the members of this Honorable House, but also for the members of the public. And Mr. Deputy Speaker, the provisions of this bill have been a long time in coming, a number of years. And as the Honorable Attorney General will have mentioned, the original iteration of the bill would have faced a number of concerns and comments and feedback from certainly members of the bar and other interested persons. The contents of the bill addresses issues such as child witnesses and other vulnerable witnesses. It deals with certain circumstances which arise out of claims of sexual abuse and other abuse. And Mr. Deputy Speaker, in my capacity as a practicing attorney and certainly as a member of government between 2015 and 2020, a number of issues which this bill would now address would have arisen at that time. I can certainly recall situations where parents of vulnerable children, of children who would have been sexually abused, would have been concerned and hesitant for their children to come before the court, not once, but twice, to give evidence at a preliminary inquiry and again at the trial, and to face the accused. And so in many instances, parents would have been hesitant to subject their children to that. And so when the Honorable Attorney General would have made mention of the fact that it may not have been as a result of lack of moving forward by the police, it may have been as a result of the unwillingness of persons impacted to have to go through the trauma of a trial, of a preliminary inquiry, of having to face the person in front of them who would have committed a heinous act. And so this bill offers a number of measures, including the fact that the accused will not directly question the child or the witness who is impacted in this case. And instead, there's an intermediary, a third party, it's called the interpreter, who will address the concerns or address the issues. And in certain circumstances in the bill, I see that there will be no persons who will be robed. And again, that goes towards the intent to ensure that the person who is given evidence, the complainant, feels comfortable in giving the evidence and does not feel intimidated. Mr. Deputy Speaker, this bill comes on the heels of a criminal justice training which would have recently taken place on the 26th of March 2024, and it would have been facilitated by Her Excellency the Governor. And so we thank the trainers, which would have been Linda Gibbs, KC, and Peter Rook, KC, the facilitators, who would have conducted this training. And the training would have been, in large measure, assisting in dealing with vulnerable children, vulnerable witnesses. Because as we recognize, Anguilla would not have necessarily had the training, the facilities in place to be able to appropriately deal with these circumstances. And so it is commendable that these King's Council would have attended Anguilla from the United Kingdom and would have provided the training for lawyers, for persons within the social development structure to be able to more effectively deal with these sort of situations. And so I see this bill working hand in hand with the training, and collectively they ought to be able to bring a great measure of assistance and development to the area where we have been lacking for so long. And so, Mr. Speaker, I commend the work that has been done in relation to this bill. Of course, over time, there may be a need to come back and to enhance, etc. I also see that the provision for civil proceedings and live link is now set out in this bill, although we know that it has been in practice certainly since COVID, but it is good that we have it encased in legislation in this region. I do have one question for the Honorable Attorney General, and I hope on his response he's able to address, and that is in relation to the committee stage amendments. Number 3, it states that in Clause 4 would delete the phrase Governor in Council and substitute the Chief Justice. And Clause 4 speaks about special measures available to eligible witnesses. And 4.2, as it is now, states that the Governor and Council may by regulation make such amendments to the Act as he considers appropriate. And so what I am understanding the proposal to be is that instead of Governor Council, it would be substituted by the Chief Justice, may by regulation make amendments. And I am curious in terms of how this would apply in practice, where the Chief Justice will make a regulation, may by regulation make such amendments. So I'm hoping that the Attorney General would be able to shed light in relation to that proposed amendment to this Act. And other than that, Mr. Deputy Speaker, I rise in support of this bill. Thank you.
Thank you, Honorable Member from Sandy Hill. Are there any other contributions? The Honorable Member for Valley South is recognized.
Morning, colleagues. Morning, Mr. Deputy Speaker, or Mr. Speaker. Morning, colleagues. I just rise generally to give my support to this bill. I know how much work the Honorable Attorney General and his team have put in bringing this momentous piece of legislation before this honorable House, and we're really at the stage of modernizing our judicial system. Madam Speaker, I can speak on two instances from two particular points of view, Madam Speaker. One from the social development. Did I call you Madam Speaker again? My apologies, Mr. Speaker. And I'll be very brief. I speak specifically from my capacity as Minister with responsibility for social development and the number of cases specifically in relation to sexual offenses committed. I know that the Honorable Attorney General said young women, but the real correct term is girls and children, because they are children who have not seen a trial in one instance, in some instances, and in others would have started trial and subsequently would have dropped the suit as a result of unwillingness to continue through the very traumatic process of coming to this, this venue to go to court and to relive those traumatic events before the court. And so, Madam Speaker, last time, Mr. Speaker, it is a question of how willing we are to amend our criminal justice procedures to accommodate the reality of the experiences we have here on a practical level in relation to the administration of justice. And the question, as the Honorable Attorney General asked, is what are we really trying to get to the bottom of? Aren't we trying to get to the truth? And the question of getting to the truth is there are the means put forward within this legislation sufficiently enable any person to adequately or more than sufficiently get to the truth of a matter. And so from that perspective, Madam Speaker, I must support the protections that have been put in place, and I must state on record these protections are not only for witnesses, but the protections also extend to an accused who is particularly vulnerable. And so there is a balancing of the scales throughout this legislation to ensure that justice is not seen to be an unbalanced or unduly weighted in one's favor or the other, as we know that the scales of justice should hang equally. On the other hand, Madam Speaker, we speak to the treatment of persons who are under the age of 18. Oh, that's the fifth time? You have to keep a count now. Mr. Speaker, I'm sorry, I'm not used to seeing you up there. So habits are hard to break. But he does look good, he does look good. But as it relates to the treatment of persons under the age of 18, Mr. Speaker, I will recount very briefly the case of James Bulger, which is a UK case. I studied in the UK for my law degree, so this came up in our youth justice seminars. And it was the case of two 10-year-old boys who would have picked up a 4-year-old child from a mall and would have then gone on to kill that 4-year-old boy. And it really was a turning point in terms of the youth justice system in the UK in relation to how they treated the two 10-year-olds. And then after that case was heard, Madam Speaker, the case went to the European Court of Human Rights and was challenged. Mr. Speaker, went to the European Court of Human Rights, and the European Court of Human Rights held that the trial that was held was unfair. It was an unfair trial in relation to those two boys. And what then spurred out of that ruling was a number of protections and changes in the administration of justice to ensure that young, whether it's accused or witnesses, were treated in a specific manner to ensure that they understood the criminal procedures that were placed and charged, that they were charged with or placed before them, to ensure that they understood the entire trial proceedings and that it did not place a situation where they could not really comprehend the gravity of the trial. And so you would have some changes such as less formal settings, the abandonment of robes and wigs that would have taken place prior, the introduction of persons to sit with younger witnesses to translate or help them to understand the trial process. And so we see a number of those changes reflected, some of them reflected within the Administration of Justice Act that is before us. And just to make it clear, because I know there are a number of concerns in relation to whether or not those protections that are being granted would erode away in the ability to hold persons who are come to court for violent crimes accountable for those matters, whether or not those protections erode away against being able to find them guilty. And I will say that we unfortunately have a case that is much closer to home, where Sean, who is a young man from my district, would have gone to the UK and would have been murdered by two 12-year-old boys. And the adjustments in that court case, of course, it was a very tragic circumstance, Mr. Speaker, and the adjustments in that particular case, which included some changes to the setting and in relation to the roles and other protections, did not prevent them from finding those two boys guilty. So if it is a matter of concern in relation to being able to find persons guilty for offenses, that is not what this Administration of Justice Act is doing. It is actually ensuring that the scale is balanced so that you don't have an instance where a case can be thrown out or be held to be an unfair trial as a result of no attempts being made to adequately address the circumstances before the court. And so, Madam Speaker, Mr. Speaker, I put forward this morning my support for this Administration of Justice Special Provisions Act as it seeks to modernize our criminal justice system and deal with substantive matters of practice that we have seen affecting the ability to access justice in our system. And I want to thank the Attorney General's Chambers and the Honorable Attorney General for the work that has been done to make this a reality.
Thank you, Member. Are there any other contributions? If there are no other contributions, I ask the mover to respond.
Thank you, Mr. Deputy Speaker, and of course to all colleagues who have voiced their support for this measure here this morning and before this morning. I am particularly thrilled to have your support, because while working through this with the team, We tried our best to ensure that the perception is not that we're coming after any particular person. We're not doing that. We're coming to the aid of persons who need help. And so this is how this measure should be viewed, as an improvement in our system so that it better works. It is a bit of a swan song for me and the team, because I think this is the last major legislative measure that will stand in my name, because I will shortly be demitting office. I think the only other measure that will come, and it's of a perfunctory nature, the bill regarding law revision, because there's been a very massive law revision exercise that had been underway for the last 2 years, so that we will have consolidation and revision of the laws of Anguilla up until the 31st of December 2022. And so I hope that will be with you shortly. More to the Honorable Leader of the Opposition's questions, I will try and do my best. In relation to the adjustment in the clause 4, the insertion of Chief Justice in place of Governor and Council, there's another amendment that will come. That is just a phrase that will be deleted. We will also be deleting the phrase, make such amendment to this act as he considers appropriate. That will be deleted. But that regulation, empowerment, shifting from Governor and Council to Chief Justice, the main reason is this. It is because the special measures, their content and the altering their nature would be really a judicial function, so that we prefer that the Chief Justice be able to step in and add to it, not necessarily to repeal anything. As you would see from what follows below, add to them or remove any measure that's not working. So we prefer that to have been, it's more of a judicial nature, so we remove that from Executive Council. That is the principal reason. I'm not sure if I captured it all. There was another one in relation to, that was it. All right. So that is the principal reason for that. All right, just bear with me, I think.
If I may, Mr. Speaker, I know this is unorthodox, but just to follow up in terms of the AG's explanation, is it that the Chief Justice will make, in terms of practice, make the recommendations and then send on to the Attorney General's chambers?
If I suggest, maybe we can discuss that.
Oh, yes.
Committee stage.
Yes, certainly in committee, yes, sorry.
Okay, thank you.
No, the modality is that the power here, the regulation would set out types of special measures and scope for certain kinds of special measures. It will not come to the Attorney General's chambers at all. We won't get involved with that, because these special measures would generally be those produced by a trial judge in the course of trial. And so, as a way of giving guidance, under our law, it would empower the Chief Justice, just as the Chief Justice can make rules on cost and so on, would empower the Chief Justice to make some sort of intervention on types of special measures, because that would be informed. Let me put it this way. I am aware that they are following developments with other pieces of legislation like this one. We are the first to come this far. So they will have some informed recommendation and some informed special measures that the judges in the Eastern Caribbean circuits would benefit from. So we put it in here as Chief Justice rather than the Governor and Council. Let the courts deal with their stuff on special measures. That shouldn't occupy politicians. That was the main reason. Right, so Mr. Deputy Speaker, I have notes here by an eager staff because they know that this is really a major deal for them. I see a note saying, remember to do accordingly. So they are the boss. Just give me 1 second to make sure I've traversed all that they have tabbed out here and written in red ink. I believe I have. These are really for the next stage of our discussion. So with these interventions and very useful commentary by colleagues, may I thank you, Mr. Deputy Speaker, the leader of the opposition, the Honorable Premier and his team, for their very robust and unwavering support on this measure, which is of vital importance at this time. I thank you.
It has been moved and seconded that a bill shortly entitled A Bill for Administration of Justice Special Provisions Act 2024 be now read a second time. Those in favor? Those against? The ayes have it. I call upon the clerk to read the bill a second time.
An act to provide for the imposition of special provisions for the giving of evidence by vulnerable and intimidated witnesses, judge-alone trials in criminal proceedings, special procedures for the admissibility of evidence in criminal proceedings, anonymity orders, special rights and procedures of appeal for both prosecution and accused, and connected justice matters.
Under Rule 45 of the Legislative Assembly Rules of Procedure, the bill now stands referred to a committee of the whole Assembly to consider it clause by clause. Assembly in committee.
Clause 1.
Mr. Chairman and the members, there are some proposed amendments to Clause 1, which is the definitional provision. The proposal is that there should be inserted Chief Justice and a definition of Chief Justice, which means Chief Justice of the Eastern Caribbean Supreme Court.
Can I get a seconder, please?
Mr. Chair, I'd like to second.
I put a question that Clause 1 be amended as proposed. All in favor?
Aye.
Those against? The ayes have it.
Clause 2.
Again, Mr. Chairman, this, if you would permit me, just some explanation. During the consultative, the public consultative engagement of the chambers with members of the public who attended, and with the bar, both by exchange of correspondence and the usual email of suggestions and commentary on the bill, some notable practitioners in the criminal bar had some difficulty with the expression that occurs quite often in part 2 of the bill relative to special measures. Mind you, special measures are a broad expression that embrace a number of things. It may be an arrangement in the court where the young victim is shielded or sealed off by a screen from actually having to see the person accused of abusing them, so as to mitigate the trauma and the like. in relation to those measures, there's a recurring expression, which is to improve the quality of the witness's evidence. Some exception, in one case, trenchant exception was taken with that expression because it suggests, so it was believed, that those measures will in some way put words into the mouths of witnesses. That's not the case. So we have put a fulsome definition of what the reference to quality of a witness's evidence means in this context. And it means really those circumstances and objective conditions which impact the witness's ability to give evidence and its quality in terms of completeness, coherence, and accuracy. That really is the mischief, in a mouthful of English, that the provisions are designed to remove. And so, Mr. Chairman and colleagues, in clause 2, the proposed amendment is by deleting subsection 5 and substituting the following expression that appears before you, part of which I just read. Thank you.
Can someone 1 second, please? The amendment.
Mr. Chair, I'd like to second the amendment.
Thank you.
I put a question that clause 2 be amended as proposed. All in favor? Aye. Those against? The ayes have it.
Clause 3.
Oh, no, sorry, go ahead.
I put a question that clause 3 do stand part of the bill. Those in favor? Those against? The ayes have it.
Clause 4.
Mr. Chairman, again, this is an area of proposed amendment to the existing bill. In clause 4, by deleting the phrase governor and council, colleagues would notice that this is the very provision that the Honorable Leader of Opposition had a query about and to which I responded. So deleting the phrase governor and council where it appears in subsection 2 and substituting the phrase Chief Justice, and B, deleting paragraph 3A in its entirety. Thank you.
Seconder, please.
Mr. Chair.
Mr.
Mr. Chair, I second.
I put a question that clause 4 be amended as proposed. All in favor?
Aye.
All against? The ayes have it.
Clause 5.
I put a question that clause 5 do stand part of the bill. All in favor? Those against? The ayes have it.
Clause 6.
Thank you, Mr. Chairman. Again, this is an area of amendment. We propose clause 6 be amended by deleting in paragraph 6D the phrase "and in particular circumstances under which such an application is to be disclosed to or withheld from a party to the proceedings." The genesis of that is the concern by colleagues at the Bar Association, and I agree with them, that since the liberty of an accused person would be at stake in these proceedings, I can't conceive justifiably, certainly from where I sit at the moment, why critical information for measures under 6 should be withheld. So we propose to delete everything that follows that phrase in 6D. Thank you.
Seconder, please.
Mr. Chair, I second.
I put a question that clause 6 be amended as proposed. All in favor? Aye. Those against? The ayes have it.
Clauses 7 through 14.
I put a question that clause 7 to 14 do stand part of the bill. All in favor?
Aye.
Those against? The ayes have it.
Clause 15.
Thank you, Mr. Chairman. Mr. Chairman, in relation to clause 15 of the bill, we propose to amend the clause 15 in the following manner by deleting in subsection 6, or really it should be subclause, so forgive me if I say subsection, paragraphs A and B, and substituting the following new paragraphs. And I don't wish to traverse them. They appear before colleagues. A to C. The important observation to be made here is the insertion of a B, because you would notice from the first iteration of the bill that at the time of first reading, there were only 2 sub-paragraphs, A and B. So what was B is now C. There's an introduction of a new B, which says where new and relevant matters have arisen from re-examination. This is normally the case in the practice in a criminal trial. So if something new comes out of the recorded cross-examination or re-examination of a witness, there is no justifiable reason why the right to pursue examination of those matters should be fettered or excluded. So this has been inserted. Thank you very much, Mr.
Seconder, please.
Mr. Chair, I second.
I put a question that clause 15 be amended as proposed. All those in favor? Aye. Those against? The ayes have it.
Clauses 16 through 33.
I put a question that clause 16 to 33 do stand part of the bill. All those in favor? Aye. Those against? The ayes have it.
Clause 34.
Thank you, Mr. Chairman. The proposed amendment here is by deleting paragraphs A and B of subclause 3 and substituting the following, which is the new A, B, and C, and in relation to D, deleting subsection or subclause 7 as appears on the proposed amendments before colleagues. I don't propose to read them all. Thank you.
Second, please.
Mr. Chairman, I second.
I put a question that clause 34 be amended as proposed. All in favor? Aye. Those against? The ayes have it.
Clauses 35 to 43.
I put a question that clauses 35 to 43 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clause 44.
Thank you, Mr. Chairman. Once again, we propose amendments to this clause by inserting in subclause 2 the phrase in parenthesis prosecution or defense after the phrase or expression parties to the trial. Thank you.
Seconder, please.
Mr. Chairman, I second.
I put a question that clause 44 be amended as proposed. All in favor? Aye. Those against? The ayes have it.
Clause 45.
I put a question that clause 45 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clause 46.
Thank you, Mr. Chairman. Again, in relation to clause 46, we propose to amend this clause by inserting the phrase with written reasons for such decision after the phrase determination thereon. Thank you.
Mr. Chairman, I second.
I put a question that clause 46 be amended as proposed. All in favor? Aye. Those against? The ayes have it.
Clauses 47 to 48.
I put a question that clauses 47 to 48 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clause 49.
Mr. Chairman, we propose to amend clause 49 in the following way. And the difference with the first, between this and the first iteration will become obvious. By A, deleting subparagraph 1A8 and substituting the following a new subparagraph 8. That is to say that legally inadmissible evidence was admitted by the court and there is not sufficient admissible evidence to sustain the decision after rejecting such inadmissible evidence. Or, and B, deleting subparagraph 1B, Roman numeral 1, and substituting the following Roman numeral 1, that the decision is unreasonable or cannot be supported having regard to the evidence or the totality of the evidence. Of course, it is intended to cause the court to look at things in the round and not just a particular aspect. Those are the proposed amendments under clause 49. Thank you.
Mr. Chairman, I second.
I put a question that clause 49 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clauses 50 to 51.
I put a question that clauses 50 to 51 do stand part of the bill. Those in favor? Aye. Those against? Ayes have it.
Clause 52.
Mr. Chairman, propose amendments to this appeal section in clause 52 by means of the following: by A, B, and C. In relation to A, deleting the word not obtained where it appears in paragraph 9A and substituting the phrase refused by the Court of Appeal. And B, deleting the phrase terminating rule where it appears in subclause 14 and substituting the phrase terminating ruling. And C, deleting the word discontinued where it appears in subclause 15B and substituting the phrase permanently stayed. Those are the amendments. The proposed amendments. Thank you.
Mr. Chairman, I second.
I put a question that clause 52 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clauses 53 to 54.
I put a question that clauses 53 to 54 do stand part of this bill. Those in favor? Aye. Those against? Ayes have it.
Clause 55.
Mr. Chairman, in relation to clause 55, we propose a very brief amendment. And by my notation here, it is a little bit more than what was originally printed for clause 55. So I'll traverse it with care. In clause 55, by deleting the word confirm, where it appears in subclause 1, and substituting the phrase affirm. So deleting confirm and substituting affirm. Also, Mr. Chairman, the same deletion and substitution must occur in relation to clauses 55 subclause 3 and 55 subclause 7. Those are the proposed amendments.
Mr. Chairman, I second.
I put a question that clause 55 be amended as proposed. Those in favor? Aye. Those against? The ayes have it.
Sections 56 to 60.
Thank you, Mr. Chairman. The proposed amendments in relation to clauses 56 to 60 is by deleting those clauses entirely. The deletion of clauses 56 to 60. Thank you.
Seconder, please.
Mr. Chairman, I second.
I put a question that clauses 56 to 60 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clause 61.
I put a question that clause 61 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clause 62.
Mr. Chairman, we propose to amend clause 62, in the following manner. By A, deleting the definitions of qualifying evidentiary ruling and the relevant condition. B, deleting the phrase or 56 sub clause 5, where it appears in subclause 3, and one further, deleting the word either before subclause 52(4). Sorry, those are the amendments we propose to clause 62.
Honorable Attorney General, can you repeat the last part of the amendment?
Yes, the last part is to delete the word either, E-I-T-H-E-R, either, or either, some people say, before clause 52, 4, clause 52, subclause 4. Thank you.
That appears to be in clause 62, subsection 3. Right?
First one is to delete.
No, I'm saying that that's clause 62, but it's referring to clause 62, 3, where it talks about either section 52, 4, 6, 5. So that's in 3, yeah.
Right,
Just to point out where it's located.
Oh,
right,
okay,
right.
thanks.
Yes. Thank you.
Well,
Seconder, please.
Mr. Chairman, I second.
I put a question that clause 62B amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clause 63.
Right, Mr. Chairman, the proposed amendment here to clause 63 is to delete the phrase each case where it appears in subclause 2 and substitute with the phrase the case. Thank you.
Mr. Chairman, second.
I put a question that clause 63 be amended as proposed. Those in favor? Aye. Those against? The ayes have it.
Clauses 64 to 65.
Mr. Chair, I have a question.
Go ahead, sir.
Going back to clause 62, if we deleted 52 and 56, and we deleted from clauses 52, what is it referring to as 52 and 56? Remember, we deleted clauses. Right, 56 to 60. So if we deleted those, is 56 correct to stay in 63, or is that? Remember, we are in clause in 62, subsection 3, we talked about removing either in front of section 52.4 or 56.5, but if we deleted 56, is that still relevant?
Because one of the amendments was that we delete clauses 56 to 60. So the question is it still relevant for us to be deleting the phrase of from 56.5?
I assume we will renumber those, but would it be appropriate 56 for that, or is that a different number?
No, it just says delete the 65 where it appears in subsection 3 of clause 62.
Right. But do we still have 56.5?
No, that's why we're deleting from the reference in clause 62.
Okay, but we were just deleting the word either, we were not deleting.
But this is an additional amendment that we added to that's not on the sheet, so we delete it from there.
Okay.
The either word isn't on this amendment sheet. If you like to do that.
Right. But what was that, AG was just, Honorable AG was saying, delete the word either. He didn't say to delete what comes after either, which is section 52.4 or 56.5. Unless you want that removed.
I think the Honorable Premier's thing is, how can we remove, say we are removing a part of 56 when we've already deleted the entire section of 56? Is that it was already amended and deleted the entire section? Oh, okay.
Clause 66.
All right, Mr. Chairman, the proposed amendment here to this clause is by inserting in paragraph C the phrase by practice direction after the phrase Chief Justice.
Mr. Chairman, I second.
I put a question that clause 66 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clauses 67 to 68.
I put a question that clauses 67 to 68 do stand part of the bill. Those in favor? Aye. Those against? Ayes have it.
Clause 69.
Mr. Chairman, the proposed amendment to clause 69 is by inserting in paragraph B the word generally after the phrase under this act. Thank you.
Mr. Chair, second.
I put a question that clause 69 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clause 70.
Right. Mr. Chairman, the amendment here in clause 70 is to make clear the entrustment of the power to make rules as distinct from the power to make regulations. And in clause 70, the amendment proposed is by A, deleting the marginal note and substituting the following marginal note: power to make regulations and rules. B, deleting subsection or subclause 1 and substituting the following. Subclause 1, governor and council may by regulation make different provisions for different cases, circumstances, or areas, and may contain such incidental, supplemental, or saving and transitional provisions as the governor and council considers appropriate. Those are the amendments proposed under this clause.
Seconder, please.
Mr. Chairman, I second.
I put a question that clause 70 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clause 71.
Thank you. Once again, Mr. Chairman, there is a proposed amendment here under Clause 71. Very brief amendment. Proposal is to amend Clause 71 by inserting the phrase, quote, and Part 11 shall apply accordingly to all civil proceedings after the commencement of this act, close or end quotations, after the phrase on or after the commencement of this act. Those are the proposed amendments.
Seconder, please.
Mr. Chairman, I second.
I put a question that Clause 71 be amended as proposed. Those in favor? Aye. Those against? Ayes have it.
Clauses 72 to 75.
I put a question that clauses 72 to 75 do stand part of the bill. Those in favor?
Aye.
Those against? Ayes have it.
Schedule 1.
I put a question that Schedule 1 do stand part of the bill. Those in favor? Aye. Those against? Ayes have it.
Schedule 2.
Mr. Chairman, the proposal is that the entirety of Schedule 2 be deleted. That's the proposed amendment to excise Schedule 2.
Mr. Chairman, I second.
I put a question that Schedule 2 be deleted as proposed. Those in favor? Aye. Those against? Ayes have it.
The title and the enacting clause.
I put a question that the title and the enacting clause do stand part of this bill. Those in favor? Aye. Those against? Ayes have it. The Assembly will now resume its sitting. I ask for the mover to report.
Very grateful, Mr. Deputy Speaker. Mr. Deputy Speaker, I beg to report that the bill shortly entitled Administration of Justice Special Provisions, Bill 2024, has passed through the committee stage with amendments and is now ready for its third reading.
A bill for Administration of Justice Special Provisions Act 2024, third reading.
I thought it would have been seconded. Okay. Many thanks. Mr. Deputy Speaker, I beg to move that the bill shortly entitled Administration of Justice Special Provisions Act 2024 be read a third time and passed.
Mr. Speaker, I rise to second.
I put a question that a bill for Administration of Justice Special Provisions Act 2024 be read a third time. Those in favor? Aye. Those against? The ayes have it.
An act to provide for the imposition of special provisions for giving of evidence by vulnerable and intimidated witnesses, judge-alone trials in criminal proceedings, special procedures for the admissibility of evidence in criminal proceedings, anonymity orders, special rights and procedures of appeal for for both prosecution and accused and connected justice matters.
Bill read a third time and passed.
A bill for Pensions Amendment Act 2024, first reading.
Honorable member for Island Harbor is recognized.
Thank you, Mr. Speaker. Good morning to you, Mr. Speaker. Good morning to staff of this House, to honorable members, to those listening and watching these proceedings. Mr. Speaker, I beg to move that a bill shortly entitled A Bill for Pensions Amendment Act 2024 have its first reading.
Mr. Speaker, I raise a second.
I put a question, a bill for Pensions Amendment Act 2024 be read a first time. Those in favor? Aye. Those against? The ayes have it. I ask the clerk to read the bill for a first time.
An act to provide for miscellaneous amendments to the Pensions Act to improve on the administration of the pension system.
Bill read a first time.
A bill for Tax Information Exchange, International Cooperation Amendment Act 2024, first reading.
Member for Island Harbor is recognized.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled A Bill for Tax Information Exchange, International Cooperation Amendment Act 2024 be read a first time.
Mr. Speaker, I rise a second.
I put a question that a bill shortly entitled A Bill for Tax Information Exchange, International Cooperation Amendment Act 2024 be read a first. I now ask the clerk to read the bill a first time. No. Sorry. Those in favor? Aye. Those against? Ayes have it. I now ask the clerk to read the bill for a first time.
An act to amend the Tax Information Exchange, International Cooperation Act 2016.
Bill read a first time.
Private members' bills? None. Private bills? None. Other orders of the day?
Honorable member for Road South is recognized.
Thank you very much, Mr. Speaker. I'd like to ask leave to recognize the fact that the Honorable Attorney General will be in this Honorable House for the last time. If it would allow us to give some parting remarks. Sorry? No, he won't be here Friday. You'll be here Friday? You'll be here Friday. So, you are on notice.
Honorable Single Island Wide member Mr. Kenneth Hodge is recognized.
Mr. Speaker, good morning. Good morning to colleagues on both sides of this honorable House and indeed to the listening public joining us via radio and social media. Mr. Speaker, I'm going to be brief in my remarks. This morning, my attention was caught by some words that were written on the website of Moran's Alternative Affordable Funeral and Cremation Services, and I share them here this morning. Those we love don't go away. They walk beside us every day, unseen, unheard, but always near, still loved, still missed, and very dear. Mr. Speaker, those words are so appropriate as I share a few brief condolences at this time to all the families who have lost loved ones over the recent period. And in particular, Mr. Speaker, we think at this time of the late Claudius Ricardo Gomes, we know him as Ghost. A tall individual, Mr. Speaker, lived right there in the village of Stony Ground, an accomplished truck driver, went about his way very quietly in the community, Mr. Speaker. He will be laid to rest this coming Saturday at the Pro Cathedral. Mr. Speaker, my dear colleague and good friend, and just retired Permanent Secretary of Finance, Mrs. Kathleen Rogers, her brother Lanville, and other members of their family over the passing of their father and family member, Eugene Harrigan, and we think of his widow at this time, Mr. Speaker. To my good friend over in Island Harbor, Ron and Dawn and Mother Sylvia and other members of the Webster's family over the passing of Ren, very jovial lady, and we think of her daughter at this time as well. And today we remember the family of the late revolutionary hero, Mr. Valentine Ruwan, also known as Bobby of Pond Ground, East End. And Mr. Speaker, I crave the indulgence of this House, if I may ask for a moment of silence, if members could stand as a mark of respect for the late Bobby Valentine Ruwan, please.
Yes. That moment begins now.
Thank you, Mr. Speaker.
Y'all may be seated.
We all know Mr. Valentine Ruwan. We all knew him as Bobby, a foot soldier in the Anguilla Revolution, participated in many demonstrations and protest marches as a close ally of the revolutionary leader, Mr. James Ronald Webster, who helped guard the beaches at night to prevent invasion. And Mr. Speaker, we all know that he was the engineer on the Rambler. That was a 35-foot open motorized sloop because he was the engineer that kept the engine running. And Mr. Speaker, back in those dark days of '67, one wonders in those dark, treacherous seas how those brave men made that journey. But he was counted among those, Mr. Speaker, who made that journey. And he would have been awarded just last year at the Anguilla Day Awards. And we are grateful as a nation, Mr. Speaker, that we will be awarding him a national funeral sometime later during this month. Mr. Speaker, as part of the activities marking Anguilla Day, I would have had opportunity to attend Blestival, a celebration of transcendent traditions, on Monday, May 27th at the Christian Fellowship Church. And Mr. Speaker, I would have spoken quite at length at a recent radio program, Current Affairs, about the young people and their role in that production. And Mr. Speaker, just on Sunday afternoon, I was privileged to attend the Marlin School of Music most recent initiative, the staging of When Anglicans Perform. And you notice, Mr. Speaker, I say when Anglicans perform. No disrespect to the other churches and denominations represented in this honorable House today. And the proceeds of that benefit going to advance the work of the new church hall at the building. Mr. Speaker, another opportunity to see the talents of our young people being displayed. But Mr. Speaker, it is worthy to note that the Marlin School of Music is this year celebrating 35 years of the development of youth through music education. 35 years, Mr. Speaker, noteworthy. And the Modern School of Music is under the direction of the founder, Lennox Vanterpool, and its motto, Mr. Speaker, playing is work. Mr. Speaker, I was caught by the program on Sunday afternoon, the varied talent that was displayed, and I listened as Mr. Vanderpool would have said to the gathering of parents and friends that young people the world over are eager for opportunities to help out and solve existential challenges. As adults, we are responsible for creating avenues for our young people to participate in tangible ways, using what they have and serving from where they are. Mr. Speaker, I am sure, and I take the liberty this morning to say that I am sure that my honorable colleagues on both sides of this House would have no objection when I say that this Assembly commends Mr. Vanderpool for his excellent work through Modern School of Music and other initiatives to work and build the talents of our island's young people over the past 35 years and counting. I encourage Mr. Vanderpool to keep up the good work. Thank you, Mr. Speaker, for this opportunity.
Thank you, member. Honorable member from Island Harbor is recognized.
Thank you, Mr. Speaker. Mr. Speaker, the single island-wide member would have mentioned several persons from District 1 that have passed, and you know, it's certainly it's sad days these days in Island Harbor and District 1, especially the passing of a revolutionary hero, Valentine Bobby Rowan. And it was yesterday, 57 years ago, on June 10th, when they would have gone up to St. Kitts to put a stay to the military forces and police of St. Kitts coming down back to Anguilla after they were expelled. This bravery is one that we must continue to remember. The legacy of our patriots must never be forgotten. And it took up until last year for him to be recognized with the Anguilla Badge of Honor and the King's Certificate. But justice delayed, as the member for Road South says, is not justice denied. I'd also like to remember Mrs. Darcilla Smith, who passed, and certainly family, we want to remember them in our prayers, and certainly know that these persons that have passed contributed significantly to not only to their communities, their churches, but to Anguilla. And certainly they are well known, Mr. Speaker. Remember Lauren Webster, known as Wren. And I know tourists and residents alike have spoken very highly of her when she worked at Falcon Nest, and prior to that at the hotel establishments. But what was very noticeable is I was in Cayman Islands last week and visited Health City, Cayman. And this was the same day that I learned that Wren had passed. And the nurses and oncologists there remembered her very well, remembered that she was always in good spirits, and she helped to entertain the other patients who were there, some, you know, close to passing, and she, you know, kept them entertained and made sure that, you know, they did not allow their illness to be the last thing they remembered. And so we want to thank her for that. And she has now passed, and certainly the family is in mourning. And we want to wish them strength, God's blessings and guidance. Mr. Eugene Budger Harrigan, you know, my uncle-in-law and husband of my aunt and godmother, Mrs. Violet Harrigan, who herself is a revolutionary hero and has been honored as such. And I was visiting her on Saturday, and she was telling me stories of how Budger also participated in the revolution, you know, causing or supporting the cause at that time that helped to get Anguilla to the point where it is right now. And so we must continue to recognize and honor our heroes and heroines. And certainly we just celebrated Anguilla Day, the 57th anniversary, and honoring the past, celebrating the present, and building the future. And so it is appropriate that we, as the members in this House elected by the people, for the people, and of the people, we must continue to know how we got here and what the people expect of us. And certainly, amidst all the division, amidst all the disrespect sometimes, we must continue to do the job that the people sent us here to do, which is to look out for the well-being of the people and to move Anguilla forward. We will wait till Friday, I think, to give remarks about the Honorable Attorney General. But we want to thank him for the service that he has provided to this country of ours, and wish him the best as he continues on his journey, that he be successful in whatever course he takes. Certainly, again, I want to say, you know, you have stood the ground well today, and I want to commend you for the way you maneuvered through this session of the House. We certainly wish Madam Speaker well, wherever she may be today, but know that you have, you know, filled her shoes well today, and I commend you for that. Thank you very much, Mr. Speaker.
Thank you, Member. Honorable Single Island Wide Member, Mr. Joseph Vanderpool.
Thank you, Mr. Speaker. Good morning to yourself, Mr. Speaker, to my fellow elected colleagues, to the House of Assembly staff, and to all of those listening. I don't intend to be long, Mr. Speaker. I think my colleagues did an excellent job describing families who have been affected by loss recently, and I just wanted to stand in support and extend my condolences to all of the families of the recently bereaved. I want to give, I wouldn't say special condolences, but I want to give especially my sympathies to the family of Miss Lauren Webster. My heart goes out to Ron, Lisa, Mut, Don, Rakev, Ma, Amo. In my times growing up through university, myself and Rakev would have gotten very close because, you know, Anguillians, when they travel abroad, they always tend to find those connections and stick to each other. So over time, I would have grown to be more so a part of the family. So I joined with them in this loss. I was surprised and shocked, and I just pray that God offers them, as well as everyone else going through these difficult struggles, comfort at this time. Thank you, Mr. Speaker.
Thank you, Member. Anyone else?
Adjournment.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that this Honorable House be adjourned until Friday, 14 June 2024 at 10 a.m.
Mr. Speaker, I rise a second.
It has been moved and seconded that this Honorable House be now adjourned until Friday, June 14th, 2024, 10 a.m. Those in favor? Aye. Those against? Ayes have it. This honorable House stands adjourned.